Hello, I'm Kelly McCullen. Joining me for this conversation are two candidates for Supreme Court of North Carolina, an Associate Justice position, the incumbent Bob Edmunds and Mike Morgan, his challenger. Gentlemen, thank you so much for being on this stage and discussing, I guess, the issues, Mr. Edmunds. Thank you for being on.
Oh, delighted to be here, and thank you and the bar for this opportunity. Glad to be here.
You know, we flipped a coin backstage, and you get the first question. I always set everyone up. One of the biggest challenges we have are people just don't know who judges and justices are.
Right.
In spite of all your fame. Tell us about yourself. What makes you qualified to continue as a Supreme Court justice should the electorate say another term?
I hope they will. I mean, my record is available on my website. I don't want to run all the way through it, though I've been a state and federal prosecutor and I've been in private practice. But the critical aspects of it, I spent 2 years on the Court of Appeals and I've been on the Supreme Court for 16 years. That means my record is an open book. Almost everything I've ever done is available on the internet. You can read my opinions, you can see what I've done. So people know what, those who have been paying attention, those who have been watching, know precisely what kind of justice I've been and what they're getting. So I think it's all laid out before them.
Mike Morgan, there's a reason you ran for office, there's a reason you're seeking this seat. What qualifications are you bringing if the voters elect you this November?
Well, I'm proud of the unique skill set that I bring to this candidacy. I've been a judge on the bench of North Carolina for over 27 years now. I've got 11 and a half current years as a Superior Court judge elected in Wake County, 10 and a half years prior to that as a district court judge, and 5 years prior to that as a district court judge, or should I say state administrative law judge altogether. So altogether 27 years with the Superior Court judgeship, the district court judgeship, and the state administrative law judgeship. So with those 27 years encompassing 3 different judgeships, I've been elevating towards the Supreme Court. In addition to that, I've been an instructing judge in the classroom. I've been on the faculty of the National Judicial College out in Reno, Nevada, located on the campus of the University of Nevada for 24 consecutive years now, teaching judges how to be better judges across the country.
What's the state of the state Supreme Court in North Carolina right now, Mr. Morgan?
I'm concerned about the apparent politicalization of what has been going on with the state Supreme Court. We haven't had the separation of powers that we typically have in terms of the fact that there's been one party that controls all 3 branches of government. And there have been some decisions that have come from this court that have caused one to have to ask whether or not we indeed have the separation of powers that we should have. And this seat that's at issue here certainly is one of those that has been challenged as being one that is not fair and impartial.
What would you say as the state of the state Supreme Court at the present moment, Mr. Edmunds?
Well, I'd have to disagree pretty thoroughly with Judge Morgan. The role of the courts is to interpret the law and be the arbiter between the various branches of government. The judiciary is an co-equal branch with the executive and the legislative. And the notion that this court has not exercised its responsibilities is just wrong. We recently had the case involving the Coal Ash Commission, where the General Assembly, the legislative branch, and the governor, the executive branch, got into a disagreement over who could make appointments to that branch, to that commission. We held that the General Assembly had overstepped itself. In the teacher case involving career teacher status, General Assembly tried to strip from the career teachers their previously earned career status. We said that they couldn't do that. In the MAP Act case, we told the General Assembly that they couldn't tie up people's property the way they'd been doing. The notion that we are a rubber stamp or just doing what people say is frankly wrong. We tell the General Assembly, we tell the executive what the law is. That's our role.
Mr. Morgan, to follow up on that, every one of these forums, we always toe the line on issues. Mr. Edmunds is citing cases that show that he thinks you're incorrect in your assertion. Are there court cases out there the state Supreme Court has made, are there verdicts or decisions they've made that made you sit back and go, all right, I got to get into this race?
Well, the redistricting case, for example, that is one that my opponent authored concerning the legislative districts. That's been declared to be unconstitutional by the U.S. Supreme Court. That's a concern in terms of that politicalization about which I speak. There's also the concern about public education in terms of the school voucher case in which my opponent participated. And in that case, again, that was an aspect of the legislative decision that was made to allow public funds to go into private schools when parents may decide to bring their students, their children, out of public schools and go into the private school system, therefore weakening the effects of our public school. In terms of those kinds of situations, those are the situations that have compelled me, along with my own personal credentials and professional credentials, to feel as though I'm uniquely qualified and best suited to occupy this seat on the state Supreme Court.
Well, you heard directly from Mr. Morgan. That's why he's challenging you, some of the decisions across the board, some of the high-profile decisions, Mr. Edmunds. How does it sit with you that potential opponents, whether it had been Mr. Morgan or not, have looked back, seen your body of work and say, because of how you've ruled, I think you're wrong, and I need to defeat you for Associate Justice?
Well, I mean, let's look at some of these cases. For instance, the school voucher case that Judge Morgan mentioned. That, what he's trying to do, I believe, is inject politics into that case. The only issue before the Supreme Court in that case was, did the General Assembly have the power to pass the law that it did? It's not our decision to make a determination whether or not it's a good law or whether it's a bad law, whether we would have voted for it if we had been in the General Assembly. The only issue was, is it constitutional? We ruled that it was. And to say, well, I would have voted against it for different reasons is not taking politics out of it, it's injecting politics into the decision.
How do you, in your present role, how do you soak in all that outside chatter and pressure and politics? Do you stay away from it, or does a justice have to read it and deal with it and set it aside and make a decision or incorporate it in some way?
Well, we take an oath that we're going to decide a case on the law and the facts, essentially. So when I walk into the building, when I do to put on my judge hat, in other words, or my judge robe, as you were, I am making a conscious decision that I'm going to put aside any politics, I'm going to put aside outside influences, that I'm going to be an independent judge making that decision based on the law and the facts. I mean, one aspect of being a judge or justice on the Supreme Court is you are guaranteed at some point to write an opinion that you personally disagree with because the law and the facts take you in a direction that you would not necessarily have agreed with if it were presented to you on a clean slate or if you were in the General Assembly. But we are the interpreters of the law, not the enactors of policy.
Mr. Morgan, to keep this discussion going, when you look at a Supreme Court decision out of North Carolina or anywhere for that matter, how do you separate that this is a policy decision I disagree with personally versus that is the wrong decision constitutionally?
Well, I've taken an oath, that oath that I have embodied for 27 years, and that is to follow the law wherever the law may take me as I look at the law and apply the law to the facts. Those laws that are enacted, they're enacted by the legislature. I am not to make law, I am to interpret law. And as a result, although I may have some personal feelings or some personal disagreement with what a law says, nonetheless, I have to apply the law to the facts. That's my oath. And in terms of being able to have any discretion in cases where I do have that discretion, I have the ability to exercise it so long as I don't abuse it. But in terms of whether or not I agree or disagree with the law, I am empowered and indeed expected to make sure that I put my personal feelings to the side and certainly any political feelings I have to the side and just concentrate on the law as it applies to the facts in the case.
You can't help what politics comes in from the outside, but I know of people well respected in political circles, analysts, consultants. They think this race is as important as the governor's race. Is this race that important to you? Is it a public service call, or is the future of North Carolina hanging in the balance? And I'll give you the first question and you the follow-up, Mr. Edmunds.
Well, I have heard as well that this is the most important race on the ballot in North Carolina, and I believe it, because this race will determine the direction in which the state Supreme Court will go. And in terms of how matters have shaped up on this court, especially in the most recent years, the fact is that there has been a politicalization of this court, and this seat is pivotal because to a great extent, this seat has participated in the politicalization of it. And as a result of that, perception becomes reality. I've heard what my opponent has said in terms of how he operates and how the court operates. But perception becomes reality to the extent that when there is any concern that a court or a particular justice is not being fair and impartial, that's a concern. People need to have the confidence that politics is not having anything to do with an outcome, and there are too many folks that look at the state Supreme Court and this seat in particular and say right now it cannot be deemed to be fair and impartial and beyond reproach.
What do you make of that this is that important of a seat and it's held by you and you want to hold on to it?
Well, first of all, remember it's the people's seat. It's not my seat. I hope the people will re-elect me to it, but that's their decision. But I disagree strongly with the notion that the court has been politicized, and I can point to things that will indicate that. There are many in not law enforcement, but in the news industry and so forth that like to say, hey, look at the court. The court's politicized, above the fold articles in like the News and Observer. But look at the opinions we've issued. The last 2 sets of opinions we issued, every single one of them was unanimous. It's not like we're a court, we've got 4 people in one party, 3 people in another, constantly at each other's throats. I think the best test is this. I've been on the court for 16 years. Everything I've done is out there. It's an open book. The men and women who endorse me, who support me, are the former presidents of the State Bar, former presidents of the Bar Association, former chief justices of the Supreme Court that cover the waterfront, from strongly liberal, strongly conservative, Democrats, Republicans. They know my work. It affects them directly. It affects their work directly. They support me.
And when it comes to public perception, public awareness, I would say, legislative, executive branch, judicial branch, judicial being very high profile right now. What's the proper balance, in your opinion? Where should the Supreme Court be? Should it be as high profile as it is, or should it be somewhere in the background behind the legislative and executive branches?
Well, traditionally it's been low profile. We do not seek a high profile. It is sort of inflicted upon us, if you want to put it that way. But we are not ordinarily considered to be a political branch. Our race is a nonpartisan race, and it's exactly that way. You look down the bottom of the ballot where the judges hang out, you're going to see 2 names and that's it. I have been running a nonpartisan race. I have not identified myself by party when I've been going out. I speak to groups like Rotary clubs and so forth. It's my opponent who's saying that this is a partisan race, or excuse me, that this is a politicized court. He's trying to inject this into the race. He's trying to say, elect me, I will change the nature of the court. I say that's a political statement.
I'll just give you the floor. I can't ask a question better than he just stated right to you.
Well, I consider it a rhetorical question, and quite amazingly to me, he says he's not putting politics into this. He puts on his yard signs that he is a, quote, conservative judge, unquote. Now, that doesn't designate a political party, but it does designate a political ideology. And that is, he holds himself out to be a conservative judge. A judge should not have any inclinations whatsoever in terms of any political leaning to somewhat target the way that he or she will rule in a case. To say that one is conservative on a yard sign or any other campaign materials in a political context automatically shows how one is going to look at a case before it even comes to one for resolution. That is the kind of premise upon which I greatly disagree that a judge should represent. A judge should not have any political leaning whatsoever, but only to apply the law to the facts and not go out and politic in such a way that one says that one is conservative or moderate or liberal at all. So indeed, it's my opponent that is constantly injecting politics in this race by using the term conservative in a political fashion as he goes about in campaigns.
How do you how do you derive a distinction in campaigns, though? If he wants to call himself a conservative on a road sign or a yard sign is one thing. You're saying, I'm not that person. I want to defeat him for office. So how do you draw a distinction without drawing real clear-cut distinctions? Why can't you say, this is what I stand for?
Well, as my opponent
It's
says,
allowed. I mean,
as my opponent says, it's a nonpartisan race. Act nonpartisan. Instead of going out and using words that are clear indications that one has a political leaning one way or another. All I know how to be is fair and impartial. That's all I ever say that I'm going to be is fair and impartial. And my peers have adjudged me that way in the North Carolina Bar Association surveys. I've got that survey on my website, www.judgemikemorgan.com. I'm fair and impartial. After 27 years, that's all I know how to be.
is there a difference if someone puts a sign in their yard that says you're a conservative, or puts one in his yard and it says I'm a liberal, or I'm this, or I'm that, or I'm moderate? Can you separate political philosophy from impartiality, or are they linked together when we elect a judge? Are we getting a liberal judge? Are we getting a conservative judge? And with that, can we expect certain rulings to go our particular way?
Well, I'm afraid we're getting a conflation here of two notions. One is political conservatism, and the other is judicial conservatism. I've run as a conservative judge. I'll tell you exactly what that means. It means, first of all, taking from the doctors, do no harm. Second, it's a belief in the rule of law, that the same facts and the same law yield the same results no matter who's in front of the court. Third, the importance of the separation of powers. I earlier talked about some of the cases where we had to be arbitrator between branches of government. We don't rubber stamp anything. Fourth, the importance of precedent. You know, that the ground isn't going to shift under people's feet just because of, who the judge is. Contracts remain the same, leases remain the same. That's what I mean by being a conservative judge. Now, by contrast, I would point out the kind of race my opponent is running. Before the primary in June, he sent out a letter to the bar listing all the county party organizations in his party that were supporting him, listing his party. He has been on his website. I've listened to a podcast where he said it was important that his party take control of the Supreme Court. I've seen, on social media, what did Judge Morgan talk about? He talked about the importance of his party taking over the Supreme Court. I've never said anything like that. I think the important thing is who's the better judge? Who is the independent judge? Who is the one that has a track record of being nonpartisan? 16 years is a pretty strong track record, I believe.
And ultimately, Mr. Morgan, judges decide, or voters decide which justices or judges I would think would be most impartial. So how do you make that case? He says, I'm a conservative judicially, not politically, and that you're affiliating with party. We can agree to disagree there. What do ordinary voters think of all this, you think?
Well, they look at him, he's a Republican, that's well known. They look at me, I'm a Democrat, that's well known. And the fact is that you don't have to mention to what party you belong, because there is a variety of a spectrum, but it's how you ideologically define yourself, and that's where he and I are different. He has ideologically defined himself politically. You can't have your cake and eat it too. You can't say on one hand that you have a certain judicial philosophy, but yet say that that word that you use in a political context, in political speeches, on political materials, is the way that you don't intend it to be, because you're looking at it in another way when you have the robe on. I think the voters are smart enough and wise enough to cut through this and to understand indeed what these buzzwords mean in a context in which they're stated. And again, I only hold myself out to be fair and impartial. I've not ever articulated an ideology politically as opposed to my opponent.
That's the last word. Time is up on this conversation. Gentleman, Mike Morgan, you're challenging Bob Edmunds.
That was 17 minutes?
That was
wow.
19 minutes on the way to 20. Gentlemen, it goes by really fast. And while you can't say this is clearly one of the top races on the North Carolina ballot, and why it's much appreciated that you watch and tune into judicial forums here on North Carolina Channel and with the North Carolina Bar Association. Gentlemen, thank you so much for this conversation. Very important to civic discourse. Appreciate it.